My name's Karen Ulmer. I'm a Pennsylvania attorney and I handle custody matters. And oftentimes people will come to me asking about the ability to move out of state with their child, or even sometimes not too far away, but it would interfere with the current existing custody order. If you're going to propose a change of residence and it's going to significantly impair the ability of the other parent or party to exercise their custodial rights, then there is a specific procedure you must follow in Pennsylvania that's set forth in Rule 1915-17. And part of that procedure is serving a counter affidavit that is a specific form on the other side by certified mail. And then what happens after that depends on whether or not the other party serves you back the counter affidavit objecting to the relocation, or if they consent. Obviously, if they consent, you can move. If you don't get it back, you can move. If you get it back certified and they object, then you're going to have to file a petition with the court. And there are, again, specific procedures to follow on that. You're going to need to show that you provided a notice of relocation, that they objected, and now you're asking for an expedited hearing. And what that means is there are some counties in Pennsylvania that require you to go to mediation or a parenting class prior to going to the judge. One such county would be Montgomery County here in Southeast Pennsylvania. And if you are in a relocation case, you can bypass having to go to those to expedite it, to try to get it in front of the court sooner, so a decision can be made. But what I tell clients often is that relocation can be despite being expedited, can still be a time consuming process. And you need to be prepared that you might not be able to relocate with your child as soon as you want. You can always relocate yourself, but relocating with your child will require the court to make a decision. And that's really subject to the court's calendar and ability to hear your case. So giving as much notice as possible to the other side is very important. And then in addition to following the procedures, which I would suggest having an attorney, just make sure you're complying with, the other part of it is then whether you meet the factors on relocation. What are the reasons why you're relocating? Are you trying to just escape the other parent, or are there real reasons that will be beneficial to your children if you relocate? Do you have another job there? Do you have family that can help? Do you have a reasonable proposed plan for the other parent to see the children? So those are all the things that the court's going to really want to analyze before they allow you to just pick up and move and relocate. So if you find yourself in the process where you want to relocate and you're not sure what to do, you should definitely consult an attorney. And if you're faced with the threat that somebody wants to take your children and move out of state, you definitely should consult an attorney, because they're not allowed to do that without the court's permission. And there are steps you're going to need to take to make sure that doesn't happen, which may include filing your own emergency petition in that situation.